Coercive neuroimaging. The paper that I read was titled Coercive Neuroimaging, Criminal Law and Privacy, a European Perspective. The central thesis of this paper is to answer the question of whether coercive neuroimaging in criminal law violates the right to respect for private life as established in the European Convention for the Protection of Human Rights and Fundamental Freedoms. So what is coercive neuroimaging? Coercive neuroimaging is to take scans of the brains of people on trial against their will. Neuroimaging could help determine guilt, legal insanity or responsibility, fitness to stand trial, and the risk of recidivism. In this paper, it compares neuroimaging to DNA testing as well as fingerprinting. And once again, the central question regarding the law of this aspect is whether coercive neuroimaging can take place and would be legal. So there are two types of coercive forensic neuroimaging. The first type is structural, which are your MRIs or your CT scans, and these are biological, for they portray the structures of the brain. The second type of neuroimaging is functional, such as fMRI or EEG, and these measure brain activities. So applying these two techniques could help with brain-based lie detection, brain-based memory detection, diagnostic neuroimaging, and neuroimaging to predict future dangerousness. A new mode of neuroimaging currently under experimentation is to use neuroimaging with machine learning algorithms that will enable researchers to identify real-time thoughts of an individual. So this has been useful in identifying suicidal thoughts. So the benefits provided by neuroimaging, should courts have a law accepting coercive neuroimaging? So coercive comes in two types. There's the physical, which is restraint, and legal, which is when negative consequences can occur if there's no cooperation. So Article 8, Section 1 of the ECHR, which is the European Convention regarding Human Rights, states, everyone has the right to respect for his private and family life, his home, and his correspondence. So what exactly constitutes private life? It's a broad concept, and it's hard to define what exactly that means. As such, when regarding the use of neuroimaging and privacy, comparisons have been made between neuroimaging and DNA and fingerprinting. So during court trials, DNA and fingerprinting are compulsory. They take them to find whether the person who committed the crime was the one on trial or not. And so questions have been asked whether using coercive neuroimaging would be any different than asking for DNA or fingerprints. It has been stated that neuroimaging violates the respect of bodily integrity, and the information garnered is more sensitive and personal than DNA and fingerprinting. But once again, the circumstances vary, and the benefits seem to outweigh the deficits. If we use neuroimaging, then we can be able to identify different court cases and help with the investigation. However, the paper concluded by stating that more legalities must be considered before final judgment regarding coercive neuroimaging can take place. Thank you.